Good evening, classmates. I'm here to continue the report on the warehouse receipts law under Act number 2137. Now, let us recapitulate what is a warehouse receipt, because this is basically what the Act is all about. It is a type of documentation used in the futures markets to guarantee the quantity and quality of a particular commodity being stored within an approved facility. Take note, it's an approved facility, not just any type of facility, but a facility that runs itself legally as a warehouse. Warehouse receipts are important because they serve as proof that the commodity is first in the warehouse or in the safekeeping of the warehouseman, and that the proper documentation has been verified by the warehouseman himself. Now, commodities need to meet specific quality standards in order to be traded as a futures contract, because these commodities are basically what needed to be stored or what's legally allowed to be stored or be placed inside a warehouse based on the Warehouse Act. Now, the warehouse receipts play a role in verifying that the necessary requirements have been met. So, in short, a warehouse receipt is a document stating first the ownership of the commodity, and it specifies the quantity, the quality, and the grade of such commodity. Secondly, it also indicates the warehouse location, the storage fee, and etc., because there are fine prints and fine details on the document itself. Now, this warehouse receipt can be sold or used to raise a loan. Second, it can also be used for delivery against a derivative instrument like futures contract. And third, it converts agricultural produce or other inventory to a tradable warrant. Now, you might ask, what is really a commodity? We hear it oftentimes, but we cannot really seem to distinguish or determine what is a commodity. Now, a commodity is a basic good used in commerce and trade that is interchangeable with other goods of the same type. Now, commodities are often used as inputs in the production of other goods or services. So it could be raw materials to create flour, or for example, grains, right? Rice, corn, or maize, and oats, wheat, barley, and all those stuff that can also be consumable but used as raw materials to create other goods or products. The quality of a given commodity may differ slightly, but it is essentially uniform across all producers. That's why there's a standard of quality that a certain commodity has to be able to reach, and that is the kind of quality that's stated in the warehouse receipt. Now, who may issue the warehouse receipt? The law says the warehouseman is a person who is lawfully engaged in the business of storing goods for profit, and no one but the warehouseman only may issue warehouse receipts. So take note. And what should be done to put the receipt within the purview of the warehouse receipts law? Only the warehouse receipt should be issued by the warehouseman. So that puts the legality of the warehouse receipts according to the warehouse receipt law. Now, we often encounter this, especially in the warehouse receipt law and in our subjects in civil law. What is really a lien? A lien is a qualified right or a proprietary interest which may be exercised over the property of another. It is a right which the law gives to a debt satisfied out of a particular thing. So in the case of the warehouseman, they also have the lien over the goods or the commodities that are being stored in the warehouse. This lien is a legal claim that one person has over the property of another as a security for the payment of a debt. Going back to Section 27 of the Warehouseman's Act, it states about the claim or the liens of a warehouseman. What claims are included therein in the warehouseman's lien? These are subject to the provisions of Section 30. A warehouseman shall have lien on goods deposited on the proceeds thereof. Okay, for all lawful charges of storage and preservation of the goods, and also for lawful claims for money advanced, interest, insurance, transportation, the labor, the weighing, the coopering, and other charges and expenses in relation to such goods. Also, for all reasonable charges and expenses for the notice and advertisement of sale and for sale of the goods, where default had been made in satisfying the warehouseman's lien. So if you take a look at the sample above, this is an example of where you can see what are the claims of lien of a warehouse or a warehouseman, no, on the property that's or commodity that is subject to the warehouse receipts. Now, if we moving forward to section 29, where most of my topics are going to be up until section 42. Now, how can the lien be lost? There are two ways. First, by surrendering the possession thereof, and second, by refusing to deliver the goods when a demand is made with which he is bound to comply under the provisions of this act. So these two things can be the means and ways wherein the lien or the claim of the warehouseman can be lost. Now, if you technically surrender the possession of the goods, therefore you transfer the possession of the goods and the liens and the claim to the liens itself. So it could be either involuntary parting with the possession of goods, while it does not ordinarily result in the loss of his lien by a warehouseman. However, a warehouseman who has released his lien by the surrender of the goods may not thereafter claim a lien on other goods of the same depositor for unpaid charges on the goods surrendered if the goods were delivered to him under different bailments or covered by separate receipts. But he has a lien on the retained goods for charges on surrendered goods where all the goods were received under one in the same bailment. So if there is only one bailment receipt that part of the goods under that one bailment receipt were already surrendered the possession of, but there is a retaining portion of the bailment of the goods from that bailment receipt that are with him, he still has claim or liens on those goods that were retained by him. Even if they were separately taken the possession of, part was already given to another's possession while the other part remains with him. So there is still a lien on that because it's still, those goods still belong to the same bailment. And secondly, if there is a wrongful refusal of the warehouseman to deliver the goods, that's one way that the lien may be lost. So section 29 talks about how the lien may be lost. In the case of PNB versus Sayo, while PNB is entitled to the stocks of sugar as the endorsee of the Kedans, delivery to it shall be effected only upon payment of the storage fees. And imperative is the right of the warehouseman to demand payment of his lien at his juncture because in accordance with the warehouse receipts law, the warehouseman loses his lien upon the goods by surrendering possession thereof. In other words, the lien may be lost where the warehouseman surrenders the possession of the goods without requiring payment of his lien, because the warehouseman's lien is possessory in nature. So if the warehouseman, in this case, surrenders the possession thereof and does not require payment, then he loses his claim or his liens. Now here is an example of a negotiable warehouse receipt. Under Section 30, negotiable receipt must state charges for which the lien is claimed. If the negotiable receipt is issued for goods, the warehouseman shall have no lien thereon except for charges of storage of goods subsequent to the date of the receipt, unless the receipt expressly enumerated other charges for which a lien is claimed. So in such cases, there will be a lien for charges enumerated so far as they are within the terms of Section 27, although the amount of the charges so enumerated is not stated in the receipt. So it is very important that when you have a negotiable warehouse receipt, it must be indicated in there expressly and written the enumeration for the charges which a lien is claimed. Otherwise, it may not be a claimable lien because those are not enumerated thereon. But insofar as they are within the terms of, again, going back to Section 27, the liens of a warehouseman, if those are within the purview of Section 27 as enumerated, even if it's not stated in the receipt, then there can still be a claim for the lien. So again, the negotiable warehouse receipts are receipts in which it is stated that the goods received will be delivered to the bearer. So there are only two persons, to the bearer or to the order of any person named in such receipt. And if you take a look at the examples that I have there on the screen, there are two examples of warehouse receipts, the negotiable and the non-negotiable. Now, in a negotiable receipt, such as the one above, if you notice, if it is a negotiable warehouse receipt, no provision shall be inserted that it is a non-negotiable receipt, because such provision shall be considered as void. Again, because warehouse receipts may be either negotiable or non-negotiable, and the negotiable receipts allow for the transfer of ownership of the commodity without even having to deliver the physical commodity to the next bearer or to the next owner. Most of the warehouse receipts in general are issued in negotiable form unless a non-negotiable warehouse receipt is indicated. So negotiable warehouse receipts are eligible as collateral for loans. Now, Section 31 states that the warehouseman need not deliver until the lien is satisfied. A warehouseman having a lien valid against the person demanding the goods may refuse to deliver the goods to him until the lien is satisfied, because we have to remember that a warehouse receipt is a written acknowledgement by the warehouseman that he has actually received and he has held or is holding certain goods therein described in the warehouse receipt, and for the person to whom the document is going to be issued, because basically this is like a bailment, kind of contract. And then the warehouse receipt here has twofold functions. One, which is a contract, a warehouse receipt contract, and also a warehouse receipt by itself. So those two shall be considered as considered and taken into consideration really between the warehouseman and the person whom he has a lien upon such goods and commodities. Now, if you have to remember again, what are these claims included in a warehouseman's lien and why a warehouseman has such claims on the commodities? First, there may be lawful charges for storage. So when you put commodities or goods into a warehouse, of course, there are costs and expenses for the storage and the preservation of the goods. If, for example, these goods are needing freezing or has a certain temperature or room temperature that needed to be achieved, then there is, of course, the cost of operation for the warehouse in order to keep the temperature at bay, at the needed temperature for such goods or commodities to be properly stored. So that's one of the lawful charges. That's one of the claims that a warehouseman's lien is composed of. Another is the lawful claims for money advanced, interest, the insurance, transportation, labor, etc., the weighing, the cooperating, and other charges and expenses in relation to the goods. So even, in fact, the transfer of the good and the transportation of the goods using trucks or using laborers to physically carry, or forklift, the rent of such tools or equipments, or even the personnel who would do the transportation of the goods to the warehouse. So those can also form part of the lien or the claims of the warehouseman. This time we go to section 32. A warehouseman's lien does not preclude other remedies. Whether a warehouseman has or has not a lien upon the goods, he is entitled to all the remedies allowed by law to a creditor against a debtor for the collection from the depositor of all charges and the advances which the depositor has expressly or impliedly contracted with the houseman or the warehouseman to pay. Generally, because the contract between the warehouseman and the depositor also is similar to that of a creditor and debtor, especially because there are expenses or costs as to the transportation and even the deposit of the goods into the warehouse. And remember that a lien generally stays in effect until the underlying obligation to the creditor is satisfied. Here, in the contract between the warehouseman and that of the depositor, it becomes creditor-debtor, right? The warehouseman becomes the creditor, and the obligation of that of the depositor becomes that of a debtor, since there are expenses and other charges or costs of charges in the process of depositing all of these commodities and goods into the warehouse that the warehouseman has a lien upon. So technically, if the underlying obligation is not satisfied, the creditor may be able to take possession of the property involved. Thus, section 31 and 32 speaks of the right of the warehouseman to really take possession of the property and not give back such commodity or property to the depositor unless the claims are satisfied. Now, section 33 talks about the satisfaction of lien by sale, and by sale we mean extrajudicial sale. A warehouseman's lien for a claim which has become due may be satisfied as follows. The warehouseman shall give a written notice, so there is a requisite for a written notice, to the person on whose account the goods are held, and to any other person known by the warehouseman to claim an interest in the goods. So it could be written notice to first the person on whose account the goods are sold, or to any other person who has interest on the goods. Such notice shall be given in delivery by person or registered letter, because registered letter is considered as documented registered mail, addressed to the last known place of the business or abode of the person to be notified. So either the business or office address or the residential address of the person to be notified. Then this letter or written notice shall contain first an itemized statement of the warehouseman's claim, showing the sum due at the time of the notice. So if the notice was made today, March 18, how much is the claim due and how much should this person pay the warehouseman for, and the date or the dates when it becomes due. There is going to be a specified date wherein you, or as a warehouseman, will indicate in the notice that this person should pay this amount at this specific time. Letter B, a specific or a brief description of the goods against which the liens exist. So those goods that are in his possession, those should be specified therein. Letter C, a demand that the amount of the claim as stated in the notice of such further claim as shall accrue shall be paid on or before a day mentioned, not less than 10 days from the delivery of the notice, if it is personally delivered, or from the time when the notice shall reach its destination, according to the due course of post if the notice is sent by mail. So for instance, your mail has been sent or personally delivered today, March 18, you should not indicate it less than 10 days after the delivery or of the notice. So if it was dated today and it was delivered tomorrow, March 19, so not less than 10 days. So therefore, it could be due March 29 forward. Okay, so not less than 10 days. after the delivery. That's because if you delivered it tomorrow, so not less than 10 days after tomorrow. Now, letter D, a statement also that unless the claim is paid, so this is a disclaimer, within the time specified, the goods shall be advertised for sale and sold by auction at a specified time and place. So, again, it's a written notice. You send it to either the person um, whose name has been registered as the owner thereof the goods, or who has interest of the goods, and then either delivered in person or by registered letter. And there should be an itemized statement of the warehouseman's claim, brief description of the goods, and there must be a demand of the amount of the claim as well as the due date, not less than 10 days from the day of delivery of the notice, and then a statement that unless the claim is paid within the time specified, the goods shall be auctioned for sale on a specific time and place. Also, on Section 33, as to the satisfaction of the sale, in accordance with the terms of the notice given, a sale of the goods by auction may be made to satisfy any valid claim of the warehouseman for which he has a lien on the goods. The sale shall be had in a place where the lien was acquired, or if such place is manifestly unsuitable for the purpose, at a nearest suitable place. So after all of those in paragraphs 1 and all the detailed enumerations as to the requirements of the notice and its delivery to the person of the depositor or the one who has interest on the goods, then the warehouseman can have the sale of the goods by auction. This is actually the extrajudicial sale of the goods by auction without requiring any court order. After the time of the payment, or for instance, if there is no such payment has been made after the time of the payment of the claim specified as to the notice of the depositor and it has elapsed, an advertisement of the sale describing the goods to be sold, stating the name of the owner or person on whose account the goods are held, and the time and place of the sale shall be published once a week for 2 consecutive weeks in a newspaper published in the place where such sale is to be held, and the sale shall not be held less than 50 days from the time of the first publication. If there is no newspaper published in such place, the advertisement shall be posted at least 10 days before such sale is not less than six conspicuous places therein. So for example, there has been a notice already sent to the depositor or to the name whose name the goods have been addressed to, for example, and such depositor has made no payment of the claim by the warehouseman, then the warehouseman can have an appropriate advertisement of the sale, describing the goods, describing the name of the owner or the person whose account the goods are held, and the time and place of the sale. And it must be published for 2 consecutive weeks, again in a newspaper, in a place where the auction or extrajudicial sale shall be held. And this sale shall not be held less than 50 days from the time of the first publication. So for instance, the publication was made exactly 15 days after the sending of the notice, either by personal or by registered mail to the owner of the goods. So you can have an advertisement of the auction sale for 2 consecutive weeks, and it must be published once a week, so twice at least, diba? Then the rest should be followed. Now, from the proceeds of such sale, the warehouseman shall satisfy his lien, including the reasonable charges of notice, advertisement, and sale. The balance, if any, of such proceeds shall be held by the warehouseman and delivered on demand to the person whom he would have been bound to deliver or justified in delivering the goods. And at any time before the goods are so sold, any person claiming a right of property or possession therein may pay the warehouseman the amount necessary to satisfy his lien, and to pay the reasonable expenses and liabilities incurred in serving the notices, in advertising, and preparing for the sale up to the time of such payment. The warehouseman shall deliver the goods to the person making payment, and if he is a person entitled, under the provision of this act, to the possession of the goods on payment for charges thereon. Otherwise, the warehouseman shall retain the possession of the goods according to the terms of the original contract of deposit. So there will be proceeds of the sale once there is a judicial sale made or an auction sale, and the reasonable charges of notice, all the expenses, advertisement, and the sale itself shall be deducted, and if there's any balance, then the proceeds shall be held by the warehouseman and delivered on demand to the person whom he had been bound to deliver, or justified in delivering the goods if there is an excess. Now let's go to section 34 on perishable and hazardous goods. If goods are of perishable nature or by keeping will deteriorate greatly in value, or by their odor, leakage, inflammability, or explosive nature will be liable to injure other property, the warehouseman may give such notice to the owner or to the person in whose names the goods are stored, as is reasonable and possible under the circumstances, first to satisfy the lien upon such goods, and second to remove them from the warehouse. And in the event of the failure of such person to satisfy the lien and to receive the goods within the time so specified, the warehouseman may sell the goods at public or private sale without advertising. Now, this is the difference between selling non-perishable goods versus selling perishable and hazardous goods that are being stored or deposited at a warehouse. If the warehouseman, after a reasonable effort, is unable to sell such goods, he may dispose of them in any lawful manner and shall incur no liability by reason thereof. So this is in a way a disclaimer for perishable and hazardous goods that are being stored in the warehouse. Either the warehouseman has the capacity or the right to first give notice to the owner that the owner shall satisfy the lien and remove the products or the goods from the warehouse. Or in case of failure, if the owner or depositor cannot satisfy the lien and cannot pay up the charges and all other expenses, the warehouseman may sell the goods without any need for advertisement at a private sale or even at a public sale. And if third, if he cannot sell them, and such perishable and hazardous goods may be very detrimental to the other property stored in the warehouse or to himself even, then he may dispose of them lawfully, and there is no liability as to the warehouseman in terms of disposing them, for as long as it is disposed or those are disposed in a lawful manner. Now, Section 35 talks about other methods of enforcing the lien. Since we've already mentioned from the previous sections how the liens or the claims can be satisfied either by the warehouseman keeping them or storing them, the properties, or the warehouseman giving notice for an extrajudicial sale, and or disposing if ever these are not sold and these are perishable and hazardous goods. But the remedy in Section 35 for enforcing a lien here does not preclude any other remedies allowed by law for the enforcement of a lien against personal property, nor bar the right to recover so much of the warehouseman's claim as shall not be paid by proceeds of the sale of the property. So just in case in the sale of the property and still the proceeds are not enough to cover for the expenses or the costs made by the warehouseman in the process of the deposit of such goods and commodities, there may be remedies that he is allowed to avail of. For example, exact fulfillment. If there is not enough funds that will pay off or reimburse all expenses, he can file for a case of, for exact fulfillment of such expenses. Number two, it could be a rescission of a contract, or it could be, number three, civil action for collection of the unpaid charges. Yes, it's similar to exact fulfillment. Number four, by way of counterclaim in an action to recover the property from him. So these are just some of the ways or remedies by which the lien may be enforced upon the depositor. Now, Section 36 talks about the effects of sale. After the goods have been lawfully sold to satisfy a warehouseman's lien, or have been lawfully sold or disposed of because of their perishable or hazardous nature, the warehouseman shall not thereafter be liable for failure to deliver the goods to the depositor or owner of the goods, or to a holder of the receipt given for the goods when they were deposited, even if such receipt be negotiable. So hence here, the effect of the sale, um, it it basically gets rid of the liability, right? Or relinquishes the warehouseman of the liability to still deliver that same um, goods or those same commodities back to the depositor, because the sale has been made and it has been made as a lawful or valid sale. So he cannot contest to that sale anymore, and he cannot claim that, oh, I did not receive the notice, because once it has been lawfully sold, it is considered, or it has been properly notified to the owner. Proper publication has been made, that the warehouseman has set the proper timelines for the publication as well as for the extrajudicial sale or auction sale. So the warehouseman, in effect, is no longer liable to deliver back those goods to the depositor or owner. Now, the enforcement of the warehouseman's lien, this is a form of recapitulation as to the remedies, right, of what a warehouseman can avail of in order to enforce all of his claims or the liens on the property, on the personal property or the goods and commodities being deposited to him. Number one, by refusing to deliver the goods until the lien is satisfied, and that is mentioned in Section 31. Number two, by causing the extrajudicial sale of the property and applying the proceeds of such sale to the lien. Those are in sections 33 and 34, right? There is a procedure for the extrajudicial sale as to the notice, as to the giving of the notice and the receipt of the notice, the timelines that have to be met, as well as the publication of the sale itself and the holding of the sale. So there has to be a proper procedure done, and the requisites must have to be accomplished. Number three, by filing a civil action for collection of the unpaid charges, or by way of counterclaim in an action to recover the property from him. So this is also another remedy or for the enforcement of the lien. And other remedies allowed by law for the enforcement of a lien against personal property, as mentioned in Section 35. Or to a creditor against his debtor for the collection from the depositor of all charges which the depositor has bound himself to pay. That is mentioned also in Section 32. So since the warehouseman and the depositor has that relation or contractual relationship between them as being the depositor and the warehouseman, that is also similar to the relationship of the depositor and the creditor. So the warehouseman herein takes the duties and obligations of the creditor, while the depositor herein becomes the debtor. And again, on the effect of sale of goods, number one, in case of the sale of goods, the warehouseman is not liable for non-delivery, even if the receipt given for the goods when they were deposited be negotiated. So regardless if the Warehouse receipt is a negotiable warehouse receipt. The warehouseman is no longer liable to deliver the goods to the owner, especially if there has been a valid and lawful sale. Number two is when the sale was made without the publication requirement and before the time specified by law, such sale is void and the purchaser of the goods acquires no title in them. So there are two effects of the sale, right? If the sale is lawful and if the sale is unlawful or void. Now, the sale is lawful if there was a proper procedure done from the notice to the owner, to the publication, to the timeline, up to the auction sale or extrajudicial sale made, as well as the notice also and the claims of the value or the proceeds thereafter. But if the sale was made without the proper publication requirement, even not following the timeline specified by law, because you have to follow in toto what was stated in the Warehouse Receipts Act, the sale becomes void and therefore the purchaser, the new owner, the purchaser of the goods will not acquire any title to the goods. Now, these are the acts for which the warehouseman can be made liable. Number one, if there is a failure to stamp duplicate on copies of negotiable receipts. So remember, if there is a negotiable receipt or negotiable warehouse receipt, this can be transferred also. The property or the goods or the commodities may be transferred to also another person. Therefore, it needs to be validated. It needs to be stamped duplicate, not just on the original, but also on the duplicate copies in order to validate the authenticity of the document. Number two, failure to place non-negotiable or not negotiable on the not negotiable receipt. So I mentioned earlier that there are two types of receipts as to warehouse receipts. There's a non-negotiable or not negotiable, and there's the negotiable warehouse receipt. Then if it is a negotiable warehouse receipt and on that document there is a stipulation that it is a not negotiable receipt, despite on the title prima facie being a negotiable receipt, such stipulation is void. Now, number three, misdelivery of the goods. The warehouseman can be also liable for this. Number four, failure to effect cancellation of a negotiable receipt upon delivery of the goods. So it is necessary that upon delivery of the goods, there is also a corresponding cancellation of the negotiable receipt. Number five, issuing receipt for non-existing goods or misdescribed goods. So whatever is prima facie on the negotiable instrument or on the warehouse receipt itself that is being specified and described in detail as to these goods that are existing as commodities being deposited on the warehouse, it must be the exact goods that are on the warehouse actually deposited and not just a made-up description of the goods. Number six, failure to take care of the goods. Yes, because as an ordinary deposit, as a depositary that is of the goods or commodities, then it is the obligation of the warehouseman to take care and to give or practice due diligence as to keeping these goods and commodities safe and preserving them, because these goods and commodities have values in them. And that's why there is a corresponding obligation of the warehouseman being the depositary of the goods to take care of them. Number seven is the failure to give notice in case of sale of goods to satisfy the lien or because the goods are perishable or hazardous. Again, there may be extrajudicial sale in the form of an auction sale for so long as there is, very important, a written expressed notice, either served in person or through a registered mail to the owner of the goods. Otherwise, or failure to give this kind of notice, that means, or that is tantamount to the nullity or the invalidity of the sale. Now let us proceed to Title 3 of the Warehouse Receipts Act, which is the negotiation and transfer of the receipts. Section 37 talks about negotiation of a negotiable receipt by delivery. Number 1, whereby the terms of the receipt the warehouseman undertakes to deliver the goods to the bearer. And number 2, whereby the terms of the receipt the warehouseman undertakes to deliver the goods to the order of a specified person, and such person or a subsequent endorsee of the receipt has endorsed it in blank or to the bearer. Where by the terms of the receipt the goods are delivered to the bearer, or where a negotiable receipt has been endorsed in blank or bearer, any holder may endorse the same to himself or to any other specified person, and in such case the receipt shall thereafter be negotiated only by the endorsement of such endorsee. So again, we will recall that negotiable warehouse receipts are those receipts which is stated what the goods will received will be delivered to the bearer or to the order of any person named in such receipt. So it's either delivered to the bearer or delivered to the person whose name is stated in the receipt. Now, no provision again in the negotiable warehouse receipt that states that it is otherwise, or that it is a non-negotiable warehouse receipt is valid. Therefore, it shall be void. If, for example, in this situation, or in this piece of paper or document that I presented on here on the screen, it is a negotiable warehouse receipt prima facie because it's there, it's on the title, it's on the face itself of the document. And if there is a statement in the fine print there that this is actually a non-negotiable warehouse receipt, then that is considered a void statement. Now, what are warehouse receipts? These are again either negotiable or non-negotiable, but negotiable warehouse receipts allow the transfer of ownership of that commodity stated therein in such warehouse receipt without having to deliver the physical commodity, because by virtue of the negotiable warehouse receipt itself, there can be a transfer of ownership. Most warehouse receipts are issued in negotiable form, making them eligible as collateral for loans. In other words, you can use the paper to transfer the ownership thereof without even transferring the actual commodities themselves. Now, moving on, Section 37 in gist actually talks about the manner of transferring the warehouse receipts by negotiation, which is the same as the negotiation of promissory notes and bill of exchanges under the negotiable instruments law. 1, if the warehouse or negotiable warehouse receipt is negotiable by the delivery of if the goods are deliverable to the bearer, and when it is endorsed in blank or to the bearer by the person to whose order the goods are deliverable, or by subsequent endorsee. So the first type of endorsement here in a negotiable warehouse receipt is an endorsement which is in blank and the delivery of the goods. Now, the second is the receipt which is specially endorsed. If it becomes an order receipt, and negotiation can only be affected by the endorsement of the endorsee. So if it is specially endorsed to a specific person whose name appears on the receipt or the warehouse receipt, which is a negotiable warehouse receipt, that person can only be the one who can affect the endorsement of the transfer of the commodities to another person, because that specific commodity and delivery of it was specifically for that person alone. Now, there are two types of endorsement. Again, the endorsement which is in blank, when the holder merely signs his name at the back of the receipt without specifying to whom the goods are to be delivered. So, it can be to the bearer or to the person who may sign the goods upon the delivery. Next is the special endorsement, which specifies on the negotiable warehouse receipt to whom the commodities or the goods shall be delivered, or to whose order the goods are to be delivered. So take note of those two things. Now, Section 38 talks about the negotiation of negotiable receipt by endorsement. So this was the second part of Section 37. A negotiable receipt may be negotiated by endorsement of the person to whose order the goods are by the terms of the receipt deliverable. Such endorsement may be either in blank, to bearer, or to a specified person. If endorsed to a specified person, it may be again negotiated by the endorsement of such person, either in blank, to bearer, or to again another specified person. And subsequent negotiation may be made in the same or like manner. Now, as a gist, the negotiation of negotiable receipt by endorsement, again, number one, if endorsed in blank or to bearer, the document becomes negotiable by delivery. Number two, if endorsed to a specified person, it may be, again, negotiated by the endorsement of such person either to blank, to bearer, or to another specified person. So, on the second part of the negotiation, delivery alone is not sufficient. There has to be an endorsement of the specified person. Okay, so those are the differences between the two, the endorsed in blank or to bearer, or the one endorsed to a specified person. Because in the endorsement to a specified person, the delivery alone is not sufficient. There has to be an endorsement of the specified person whose name appears on the receipt, and it can be renegotiated through an endorsement by him to another person, or to a blank to a bearer na naman. So there are three again, and it can repeat, in that particular order or in which other manner that the next endorsee may opt to choose. Section 39 on the transfer of the receipt. It states that a receipt in which is not in such form that it can be negotiated by delivery may be transferred by the holder by delivery to a purchaser or donee. And a negotiable receipt cannot be negotiated. And the endorsement of such a receipt gives the transferee no additional right. So, again, as I have mentioned, if it is stated on your warehouse receipt that it is a non-negotiable warehouse receipt, I already specifically shown that type of document. It cannot be stipulated thereon that it is a negotiable instrument. So, otherwise, if it will be negotiated, then such negotiation is invalid or null and void, and therefore there is no transfer of right or any additional right to the next recipient or to the one whose name the property or the commodity is being transferred. And then a non-negotiable receipt, again, it cannot be negotiated. Otherwise, if it is done, it is null and void. Nevertheless, it can be transferred or assigned by delivery because, as in most cases, non-negotiable receipts really need the delivery of the item or the commodity itself in order to transfer or assign the ownership thereof. The assignee or transferee only acquires the rights of the transferor or assigner. So whatever rights there are from the transferor or the assigner, those rights can only be acquired by the assignee or the transferee only, and not beyond that, not plus minus, because it is a non-negotiable receipt. So these are the advantages of a negotiable warehouse receipt. First, it protects a purchaser for value in good faith. Number two, the goods covered by the receipt cannot be garnished or levied upon under execution unless it is surrendered, impounded, or its negotiation enjoined. Number three, in case of negotiation, the holder acquires the direct obligation of the warehouseman to hold possession of the goods for him without notice to such warehouseman. And fourth, the goods it covers aren't subject to seller's lien or stoppage in transitu. Now, who may negotiate the receipt? That is in Section 40. A negotiable receipt may be negotiated by the owner thereof, and number two, by the person to whom the possession or custody of the receipt has been entrusted by the owner if, by the terms of the receipt, the warehouseman undertakes to deliver the goods to the order of the person to whom the possession or custody of the receipt has been entrusted, or if at the time of such entrusting the receipt is in such form that it may be negotiated by delivery. So, Again, it can be either the owner who can negotiate the receipt, and it could be any person whom the possession or custody of the receipt has been entrusted to by the owner. And one of that is the warehouseman, of course, if by the terms of the receipt, the warehouseman undertakes to deliver the goods to the order of the person to whom the possession or custody of the receipt has been entrusted. Or if at that time of such entrusting, the receipt is in such form to be negotiated by delivery. So those are the only two persons who can negotiate the receipt. Moving on to section 41, the rights of the person to whom a receipt has been negotiated. A person to whom a negotiable receipt has been duly negotiated acquires thereby first such title to the goods as the person negotiating the receipt to him had or had ability to convey to a purchaser in good faith for value, and also such title to the goods as the depositor or person to whose order the goods were to be delivered by the terms of the receipt had or had the ability to convey to a purchaser in good faith for value. Always take note that the rights transferred from the one person holding the titles to such goods have to be there has to be good faith, because the person who's also being conveyed the title to must be a purchaser also in good faith for value. Otherwise, if there is bad faith, then such transaction can no longer be validated, right? Because there is a knowledge of the defect firsthand or beforehand. And secondly, there is the direct obligation of the warehouseman to hold the possession of the goods for him according to the terms of the receipt as fully as if the warehouseman had contracted directly with him. So, for instance, the title of the person whose goods had been negotiated and who had the title to the goods themselves, and he or she has these rights, attached to the title. Once this title is being negotiated to another person or conveyed to another person who is a purchaser in good faith for value, that purchaser in good faith for value also acquires the rights attached to the title. Okay, but otherwise, if the person does not have those rights attached to the title, so therefore those or any other rights that were not attached to the title cannot also be transferred or conveyed to the purchaser for value, especially if the purchaser for value is buying such commodity in good faith. And so these are in gist the rights of persons to whom the receipt has been negotiated. First, the title of the person negotiating the receipt over the goods covered by the receipt. So you are passing on the title of the person. If you are the person negotiating the receipt over the goods, you're passing on that title to the purchaser for value in good faith. The second one is the title of the person to whose order by the terms of the receipt of the goods were to be delivered over such goods. So the title of this person over to whose order by terms of the receipt the goods were to be delivered over such goods. So definitely passing on the title of that person whose order by the terms of the receipt these goods were delivered. So that's the second right now of the person that you as the purchaser for value will also be conveyed upon. Number three, the direct obligation of the warehouseman to hold possession of the goods for him. So definitely, the person or the purchaser for value in good faith will also have the direct obligation of the warehouseman. So such rights and obligation will be transferred to the purchaser for value, which is the possession of the goods. All right. So in continuation of section 41, the rights of the person to whom the receipt has been negotiated. There are attachment of goods covered by the receipt. First, if the receipt is non-negotiable, meaning the transfer of a non-negotiable document of title does not affect the delivery of the goods covered by it. Accordingly, before notification, the warehouseman is not bound to the transferee, whose right may be defeated by a levy of attachment or execution upon the goods by the creditor of the transfer or by a notification to such warehouseman of the subsequent sale of goods. So if the receipt is non-negotiable and there is a levy upon the warehouse receipt, and such the transferor has an obligation to the creditor or his or her creditor, right? And these goods are being attached and executed upon, because the creditor needs to, of course, claim his rights to a certain sum or amount that the transfer or the depositor herein is obliged to pay him. But because there is a non-negotiable instrument and that the possession of the commodities are within or with the warehouseman, the warehouseman is not obliged to effect the delivery thereof of the goods, because there is a levy of attachment or the execution of the goods the creditor of the transferor has made upon such goods, and that there is, or it could be that there is a subsequent sale made by either the depositor or the transferor of those goods. But because of the virtue of it being non-negotiable as a warehouse receipt, then there is no duty of the warehouseman to deliver the goods to the transferee. Now, on the second premise, that if the receipt is negotiable, the goods cannot be attached or levied under an execution unless the receipt be first surrendered to the warehouseman or its negotiation enjoyed. So these are the main differences between the non-negotiable and negotiable receipts. Moving on. Now, section 42, rights of the person to whom the receipt has been transferred. A person to whom a receipt has been transferred but not negotiated acquires thereby, as against the transferor, the title of the goods subject to the terms of any agreement with the transferor. If the receipt is non-negotiable, such person also acquires the right to notify the warehouseman of the transfer to him of such receipt, and thereby to acquire the direct obligation of the warehouseman to hold possession of the goods for him according to the terms of the receipt. Prior to the notification of the warehouseman by the transferor or transferee of a non-negotiable receipt, the title of the transfer to the goods and the rights to acquire the obligation of the warehouseman may be defeated by the levy of an attachment or execution upon the goods by the creditor of the transferor, or by a notification to the warehouseman by a transferor or a subsequent purchaser from the transferor of a subsequent sale of the goods of the transferor. So technically, or in gist, there are three rights of the person to whom the receipt has been transferred. So we are talking here about the purchaser for value in good faith, to whom the warehouse receipt has been transferred. First, the title to the goods against the transferor, and the transferor being, it could be the owner of the property or the commodity or the warehouseman himself. Number two, the right to notify the warehouseman of the transfer thereof. So definitely, once the commodity has been transferred to your possession, being the purchaser for value, you have the right to notify the warehouseman of the transfer thereof. Or whether or not the warehouseman was the one transferring, or it was the owner himself who transferred the commodity or the receipt itself to the transferor, or the one whose name has been given or given the right to the receipt. Number three, the right thereafter to acquire the obligation of the warehouseman to hold the goods for him. So definitely, if you have been given the rights to the receipt, and you have the title as to the goods, against the transfer. You have the right to notify the warehouseman of the transfer thereof. So you can inform the warehouseman, oh, that the title has been transferred to me accordingly, validly, lawfully, and the receipt is now named after me. Then therefore I have the right to acquire the obligation of the warehouseman to hold and possess the goods for me. So then I will have there is a form of transfer of ownership. So then there is also going to be a corresponding transfer of possession. I will have the right to possess then the commodities specified in the warehouse receipts. That ends my part of the report. Thank you so much for listening and watching. Let's proceed to the next reporter.